afternoon, all the participants. Like it is again a revival of the earlier series of webinars that we had. And the tagline of all these webinars is my way of learning. Exactly, this is my way of learning, and I'm true to this spirit. Whenever I do something like this, it is actually it facilitates my learning also. I don't think we should wait more because we have substantial participants today, and we should formally start by uh, saying Ankit will actually assist me today in reading out the questions and also helping me technologically. Also, the the format that we would adopt today is that whatever we deliberate in 30 minutes, then we can take questions on those uh, issues, subjects, and then later again we start the presentation. After every 30 minutes, Ankit will take some questions. Rather, Ankit is having a difficult job to keep noting questions which are pertaining to the this part of the presentation. And also at the end, we would try to find out some time. Although the subject is very long, and I'm not sure whether it will be completed within 2 hours, because more than 2 hours will become boring for everyone. So formally, I may start again saying good afternoon to all. We are today discussing on the pre-packaged insolvency resolution process. Although uh, in some of the uh, documents it is written in short as PPIRP, I thought that it will be too difficult to say PPIRP. So we already have the habit of saying CIRP, so we can make it PIRP. Whenever we say PIRP, that actually means pre-packaged insolvency resolution process. This, as probably all participants would know, that this is a great effort by Government of India. First, they increased the limit for MSME qualification. The limit is I will actually come to the limit of plant and machinery and turnover. So that was the first effort. Then, of course, the RBI also came with the MSME relief for COVID reasons. And now this is the another very big subject, a very big step. And if you see this lightning speed of implementation, on 4th of April, the ordinance was promulgated. And the rules and regulations are in fact drafted along with the ordinance. So the rules and regulations both are notified on 9th of April. So within few days, within 3 or 4 days, everything was done. That is the lightning speed. And even the notification has also been done on 9th of April, where the amount of default is notified as 10 lakhs of rupees for MSME and for eligibility under PIRP structure. I think I would start with let me share my screen and then.
So there is a feedback on the volume. So maybe you can try and speak a little closer to the microphone. To all those people who are having an issue with the audio, I will also request you to increase your volume if possible.
Maybe I speak a little louder, and it may be better now because
certainly better.
Let me take one sip of my hot water. I'll definitely increase this with this hot water sip. I keep this hot water on my desk always. Good. So participants, today is the day for this pre-packaged insolvency resolution process for MSME corporates. and I'm presenting it, although it was very difficult for me to study the rules and the regulations, which in fact were released last evening. And since last evening, I'm trying to capture all these important regulations and rules. And I have, to a great extent, mm, captured that in my presentation. And I would be able to uh, also deliberate on the regulations. So the webinar that we are having today is it's on this prepackaged.
You
Uh,
can just put this on slide full screen slide sharing mode.
yeah. So participant, this is the ordinance, Insolvency and Bankruptcy Code Amendment Ordinance 2021. This promulgated on. It was released on 4th, and I think it was promulgated on 5th April, if I'm not mistaken. This is an alternative to CIRP, and you probably would have seen that the CIRP had its own difficulties in the last 4 years, uh, because of the cost, if the cost of the CIRP, the time taken by CIRP, the litigations in CIRP. So this particular structure, which has been devised, it is primarily for MSME, and it is supposed to be quicker for the time being. As we understand, when the CIRP came, that was also quicker, but then now also we would assume that it will be quicker. Of course, this depends upon the capacity of adjudicating authority. Secondly, it may be cost effective. Yes, it is cost effective because I have gone through every part of it. It seems to be cost effective because of the limited time available. The insolvency professionals who are appointed as RP will have to work very hard on this. It is not a small assignment. It is a very big assignment. Everything is as we do in CIRP, except for the part of the management. However, the monitoring is also part of the PIRP. The It is a kind of a consensual approach to to the resolution of financial stress of a company. The financial creditors would provide their consent, so that is the reason it actually considered to be less litigative and more of a consensual kind of resolution. The the business is also not disrupted to a great extent. The promoters are also not under fear, and they would provide the information because, in fact, the PIRP starts with the detailed information. In case the detailed information is not available, the PIRP would not even start. So the biggest thing that we were supposed to make applications under section 19.2 always in most of the applications, in most of the assignments. So that probably would not be really required in all the cases, although section 19 it is applicable in certain circumstances in this structure also. But most of it is the pre PIRP period, the pre-PIRP preparation, that actually would be able to conclude the resolution process also. So the business would continue, the jobs would be preserved. The way the company is going on, the company will go on like that during PIRP. The resolution professional would not be responsible for taking control and management of the company, and also would not be responsible for taking the custody and possession of the assets of the company. So, like as I said, this uh, the default amount, which is under section 4 of code, that has also been notified by notification number 1543 dated 9th of April 2021, and that limit has been placed at 10 lakhs of rupees, and which can be raised to 1 crore, but not more than 1 crore by any notification by central government. The structure has been made in such a manner that this the chapter 3A has been inducted in the IBC code. The sections from 54A to 54P are newly inserted sections for handling PIRP. Two more sections, 167A and 77A, one for the prosecution and the other for penalty, so has also been introduced. See, in the meantime, the regulations the rules have also been notified on 9th, and the rules says that Form 1 has been introduced for making an application to adjudicating authority for initiating PIRP for any corporate debtor. The detailed list of documents has been provided in the rules, and those detailed list of documents along with the formats which has been given in the regulations, that is something which is a consensual. The information which is actually being provided before even the company is admitted to PIRP, that information itself is enough for conducting the resolution process. So the stress of getting the information about assets, transactions, liabilities, see, that stress is not there in this particular PIRP structure. The information that is required for even getting the PIRP admitted, that information itself is sufficient for concluding and for managing the stress of the corporate debtor. The regulations have also been introduced. In the regulations, the uh, 14 forms has been introduced, uh, named as P1 to P14, and even for various applications, that are supposed to be submitted to NCLT adjudicating authority. For those also, the forms has been submitted, I think only because of standardization, and later on the electronic filing of all these forms, that probably will be captured for even creating a database. That's what seems to be the intention of the uh, regulator in this manner, because in all the forms, even the application for termination of PIRP is a form, even the application for vesting of the management with the RP, that's also a form. So the applications are like, even applications are there in the formats as forms. So there are some basic definitions which has been introduced in this structure. One is the base resolution plan, which is very important, which actually means a resolution plan which is provided by the corporate debtor. So whenever we say corporate debtor, you can also assume the provided by promoters, provided by directors, whatever you assume, but we would be using in this conversation as corporate debtor. So the base resolution plan has to be provided by the corporate debtor, and the corporate debtor, that means uh, the company itself. Now coming to the preliminary information, which also can be considered as preliminary information memorandum, that is also supposed to be submitted by the corporate debtor. See, in CIRP, we in fact has been struggling to even prepare an information memorandum. We have been struggling to get the balance sheets of the company. We've been struggling to get the provisional figures of the latest accounts. But in this particular case, unless we have all the financial information, assets and liabilities, books of accounts, as on the date of the declaration, the PIRP would not be started. So that means that we have the complete information of the assets, liabilities, and transactions of the corporate debtor before the PIRP can be started. I would the the date, PIRP date, is also very important. In most of the discussions, we will use this PIRP date, and that date means then when this adjudicating authority passes an order or declaring the commencement of pre-packaged insolvency resolution process. So the period, uh, the PIRP period, as we've been referring always, is CIRP period. Now the PIRP period is from the beginning of the um, uh, admittance of the application by adjudicating authority, and till the order is passed by the adjudicating authority, either for approval of the resolution plan or for termination of the PIRP. So that is called the PIRP period. The resolution applicant has the same meaning as we have in section 525 of the code, where the the resolution applicant in this case can be corporate debtor, or any member who has the authority under the constitutional documents, or even the CEO and the CFO of the company can also file the application for admittance of the company for PIRP structure. So there is another different kind of protection. Once the uh, PIRP is undergoing, any company which is undergoing PIRP, the financial creditor or operational creditors are not entitled to file any application for CIRP of the same company. So if a PIRP is going on, no application can be filed or can be admitted by adjudicating authority for initiating CIRP of the corporate debtor. And there is another protection also, as Dr. Sahu said in his address, that it may not be misutilized, because see, there may be a case that every time the corporate debtor may go for PIRP, so to avoid any application under section 7 or 9. But then in this particular case, the ordinance provides that no PIRP can be initiated within 3 years of undergoing one PIRP. When we been undergoing one PIRP means even if the resolution plan is accepted or not, even if the PIRP is terminated, or if the CIRP has been completed in some cases, though the PIRP cannot be initiated. So one effort of PIRP, so that means that you actually have consumed 3 years. So within 3 years, you cannot even use another opportunity for PIRP. So the promoters, they have to be very, very cautious. In case they really feel that this PIRP would be helping the financial stress of the company, they should only engage themselves into the PIRP structure. Otherwise, in case they are simply casually do the PIRP just to save themselves from any 7 or 9 application, then probably they would not be having that opportunity again for the next 3 years. So this is something, a protection, so that to avoid repeated attempts of PIRP by the promoters. So this structure is a clear analysis of section 11A in the ordinance. So this is regarding the priority of applications as it would be considered by adjudicating authority. The first scenario is that as on the 4th of April is the cutoff date. 4th of April 2021 is the cutoff date. If application, I can see, like, let us take one scenario that the application under section 7, 9, or 10 is pending as on the date of promulgation of ordinance. So if this is the scenario, then that means the application 7 or 9 or 10 is pending. So any application filed under section 54C for PIRP, or any other application under 7, 9, or 10 is filed, the PIRP would not be considered till disposal of all applications under section 7, 9, or 10. So PIRP is not to circumvent existing applications of 7, 9, or 10. PIRP can only be started if there is no existing application. It is pending pending before adjudicating authority. Second scenario is that presently, as on 4th of April, no application under section 7, 9, or 10 is pending before adjudicating authority as on the date of promulgation of this ordinance. Then the first scenario is that the application under section application for PIRP is filed after the promulgation of ordinance. Then application filed under section 7, 9, or 10 while the application under section 54 is pending. So that means my PIRP application is pending, and there are other applications which are filed after my PIRP application under section 7 or 9 or even 10 maybe in certain circumstances. Then the adjudicating authority will dispose of PIRP application before any other application is taken up. So any PIRP application that can be filed now, so that can also be a kind of moratorium that 7, 9 applications would not be admitted or would be kept in abeyance in case filed. Now, application under section 7 or 9 or 10 is filed after promulgation of the ordinance, after 4th of April 2021, and those applications are pending. Then in that case, the corporate debtor can file PIRP application under section 54C within 14 days of filing of the applications under section 7, 9, or 10. So in case the application is filed within 14 days of application under section 7, 9, or 10, then the adjudicating authority will dispose of the PIRP application before 7, 9, or 10 is disposed of. The last scenario is that the application under section 7, 9, or 10 is filed after 4th April and is pending, and section 54C application is filed after 14 days of the applications under section 7 and 9. So in this case, the adjudicating authority will first dispose of applications under section 7, 9, and 10, and then only it will be the PIRP application will be taken up. So this is the clear analysis of the priority of the applications. The conclusion that if any PIRP application is pending, no CIRP application can be accepted by adjudicating authority. If CIRP application is pending, then within 14 days PIRP application can be filed and PIRP will get preference. If CIRP application is pending and the PIRP application is filed after 14 days, then CIRP application will be attended and disposed of before PIRP application is taken up. See, continuing with the priority, like if the PIRP scenario, in case the resolution plan is approved in PIRP and the resolution plan is contravened by the corporate debtor, then any person whose interest is prejudicially impacted can file an application to adjudicating authority for passing a liquidation order under section 33. So these companies can also go into liquidation in case the PIRP resolution plan is contravened. And in that case, the resolution professional will be appointed as a liquidator, subject to his consent to be appointed as the liquidator. So this is one scenario where the company can go into liquidation in case PIRP fails. However, in other cases, in case PIRP fails, it will be terminated and the company will continue to be operated by the corporate debtors, will be operated by the same promoters and the directors. So the structure of PIRP is that way very healthy when we say that the promoters definitely can try. They can try as if the PIRP in case gets success. Of course, that would be revival. And in case it doesn't get success, they would continue to operate the company. They can continue to bring some money from their own sources, and they can also do some kind of partnerships outside the structure of uh, IBC. So this opportunity which is being given to the promoters is very, very important. But this opportunity is not coming every year. So this is an opportunity which actually can be used only once in 3 years. So there is some eligibility criteria for PIRP. So unless we are entitled to, unless we are eligible to, the PIRP cannot be initiated. So the first eligibility is that the corporate debtor should be classified as MSME under the Micro, Small and Medium Enterprises Development Act 2006. The new limits and the new criteria has been notified wide notification number 1702 dated 1st of June 2020, which is effective from 1st July 2020. And that particular limits are the new definition for MSME. I would, on the subsequent slides, I will definitely discuss this because this is very important about the eligibility. The eligibility is completely changed as we've been understanding in the past. Now it is completely changed. So there are something which is very important to be discussed today as far as the MSME status is concerned, MSME eligibility is concerned. The other part is that CD must commit a default of rupees 10 lakhs, and it is not important that the CD should be NPA. It is not important that the CD should commit a default with financial creditors only. It is not important that the CD should commit a default with the operational creditors. Any default, CD has to say that yes, the CD has committed a default, and that default actually is the first requirement of any PIRP structure to commence. to process the PIRP process to commence. Uh, the any CD which has undergone PIRP or has completed CIRP during the period of last 3 years is not entitled to. Any company which is already under CIRP cannot file PIRP application. Uh, any company under liquidation cannot file PIRP application. The corporate debtor should also be eligible under Section 29A. No, what is the eligibility under Section 29A that we need to comply with? Because of the exemption of Clause C and Clause H under Section 240A of the Code because of MSME. MSME has these two exemptions. The Clause C and Clause H of 29A is not applicable to MSME. So Clause C talks about NPA status and Clause H talks about the grantee. So now in this particular case, the residual clauses of Section 29A, which are important, are the willful defaulter. So the CD should not be a willful defaulter. Secondly, the CD should not be convicted for offense punishable with imprisonment. The CD should not be prohibited by SEBI from trading in securities. So these are prime important clauses of Section 29A. So other clauses were also there, which I thought it's not important for MSME structure. But these are the primary things that we have to see whether there is any ineligibility under Section 29A before we move for PIRP. So I think the very important is how to start with. I think the most of the professionals who are associated with me today, they would be really needing some kind of clear structure how to start with. No, the corporate debtors, they would only approach their chartered accountant that we have a financial stress and how do we use this PIRP for resolution. The first few jobs which are supposed to be done by someone who understands PIRP and who also understands the financials, that exercise is very, very important. That exercise is that we need to have updated financial information of the corporate debtor, 2 years audited balance sheet, provisional balance sheet, latest books of account, all liabilities, all assets, each and every contingent asset, litigations. All this is something which is a basic decision, contingent liabilities. These are all the facts would be basic information which would be required whether PIRP would be beneficial to CD or not. So based on all this information, as most of the professionals who are associated with us today, it is something which is a restructuring proposal that we used to make. And we also have at times be making you one-time settlement proposals with the banks. My understanding is that the restructuring, one-time settlement, everything will actually now come to us as PIRP, because the banks would not be interested in taking a single isolated decision, but a committee approach would be acceptable to most. And the committee approach also with a prior approval. With a prior approval, the committee approach is also very, very protective. So based on all this information, the corporate debtor, promoters, directors, they would try to find out what would be the best resolution plan for the corporate debtor, which will be called as base resolution plan for the resolution of the financial stress. So that will be prepared by the corporate debtor, and this is the beginning. And once this is prepared, so that is the study, that is the information compilation which is required before even the start of the process. Thereafter, if the corporate debtor feels and the consultant feels, that particular consultant who understands the PIRP and also understands the financials of the company and also understands the how the company would be revived, and it will also require kind of projections, the business plan. It will also require a kind of future revenue, future profitability, EBITDA, repayment capacity, the sources of funds, utilization of funds, and it also can have additional, it can also have additional uh, loan by the financial creditors. So this kind of restructuring plan, which would be considered as a base resolution plan, would be first prepared, and then the board of directors can sit together. They can see, yes, this is the base resolution plan. In case this kind of base resolution plan is approved, then the company can be revived, the financial stress can be resolved. Then they can sit together and they can actually the majority of the directors means like they can pass a resolution, they can pass a resolution, and so that the declaration, can be given so that declaration, there is a format for the declaration, and that format is P6, which has been given in the regulations. P6 is the format for declaration. This declaration is called declaration under section 54A, and this will talk about the eligibility of the corporate debtor, the process, and whatever process they are supposed to conduct it, they have conducted the process. So that is the declaration, and this declaration date is very, very important. So my understanding is that most of this paid work, most of the meetings with the financial creditors for understanding their viewpoint on the base resolution plan, that should be done before even the declaration by the majority of the directors. So a basic resolution plan, a base resolution plan should be prepared. It should be taken to the financial creditors to understand their requirement, to understand whether what is their viewpoint about the base resolution plan. Then in case we find that 66% of the financial creditors may be secured or unsecured, unrelated financial creditors, if they are of the opinion that they are ready to go forward and they are ready to apply for PIRP. At this particular stage, they are not supposed to say that we approve the base resolution plan. They would only say, yes, based on this base resolution plan and based on the declaration, based on the special resolution by the shareholders, members of the company, and based on some other documents which are required and which are supposed to be submitted to the financial creditors, then the financial creditors can take a decision for giving a go-ahead to file an application for PIRP. So this all has to be done within 90 days. So how do we start this 90 days? So I said first the base resolution plan, which the corporate debtor and any person who actually has the knowledge of PIRP and projections and business plan, and that is the first stage of the PIRP. Then is the second stage is the declaration and the special resolution and also the other documents. Now the third stage is, once we have this base resolution plan, now from now 90 days would start. During this 90 days, what the CD would do? The CD would also determine the applicant, who would be the applicant. The CD himself can be the applicant, any member can be the applicant, a CFO can be the applicant, CEO can be the applicant. Now that applicant will first of all communicate to the financial creditors of his intent to go through the process of PIRP and would request the financial creditors to attend the forthcoming meetings. So here is the process, which is a pre-PIRP process. So this is a pre-PIRP process where the applicant would give notices to the financial creditors for attending to the meetings where all this pre-PIRP process would be discussed. The bankers definitely would agree to, because see, accordingly, even the RBI, even the banks will also pass their own internal circulars. The banks will also consider this process as a process under the law. They would also like to comply with all the requirements. So this is also one of the requirements, that after a declaration by the majority of the directors, after a special resolution to be passed by the members of the corporate debtor, also the base resolution plan is submitted. Also the base resolution plan is submitted to the financial creditors along with the detailed list of creditors. Along with the detailed list of creditors,
then they are supposed to, they would be probably directed to participate into the meetings for discussing this PIRP. Now the applicant shall convene the meetings of unrelated financial creditors by serving a notice of 5 days. This is part of the regulations, and the notice should also provide the date, time, venue, and the mode of the meeting, and also should enclose in with every notice the list of creditors in Form P2. Now the Form P2, which is a list of creditors, I'm not saying list of claims, I'm saying list of creditors, because there are two things. One is the list of claims and the other is the list of creditors. So this is a pre-PIRP process where the list of creditor is important. Now the list of creditors is given to the banks, and they would be given a notice of 5 days. So see, earlier I was thinking, how would it be possible? There are 10 bankers. How the applicant, corporate debtor, will go bank to bank. They will try to convince them how this base resolution plan will be explained to them, each of them. But when this regulation came last night, then it became very clear that there is a process even for pre-PIRP. Now, this process is significantly much better than, because the CIRP meetings, because in the CIRP meetings, first few meetings, we only waste time on whether the RP would be retained or the IRP would be. So that part is not there. Presently there is no RP. So in case I would actually move on to the next slide. So the meetings are happening. In these meetings, in case the financial creditors are of the opinion that we should consider this PIRP, or even they can say that you improve the base resolution plan, this is something that which is not acceptable to us. They can say that, yes, we would accept base resolution plan should be not like this, it should be like this. We would not take haircut, or we would take small haircut, or we would also like you to take some haircut, or we would like you to contribute something further. We are not interested unless the new investor comes. Anything like this can be told by the financial creditor to the corporate debtor. After all these discussions in these formal meetings, then the financial creditors can say, yes, we can go ahead and we can appoint an insolvency professional who would be RP in this case. Any financial creditor who has not less than 10% of the voting share can propose a name of the insolvency professional to be appointed as RP. Or even the RP who is already coordinating with the banks, who is already explaining all the banks in all these meetings, he can also be picked up by the creditors as the person who has the knowledge, who has the experience, and who is able to guide the bankers also the entire process, and would also try to uphold the independence, which of course I would tell how the regulations are assuring independence of the RP in this case, because we are not supposed to go to the CD for asking the fee, and we are also not supposed to go to the financial creditors for asking the fee. So this process here, in case the bankers would give some to and fro, like every kind of negotiations, every kind of conditions the bankers may put to the base resolution plan, and then finally the insolvency professional may be proposed and may be selected for appointment as RP. So now at this particular time, when the RP is being appointed by the financial creditors, so there are three things that they would decide as far as the fee is concerned, because there can be three eventualities. One is that the application is not accepted by the adjudicating authority, so the RP has done a pre-PIRP role, so there will be a fee for pre-PIRP role. I would actually come later what kind of pre-PIRP role is, because see, the RP's role is starting now. So their first role is the consultancy to the corporate debtor, where the RP is engaging with the corporate debtor, and RP is also preparing a kind of base resolution plan, and that base resolution plan is presented to the banks in the meetings after the declaration by the majority of the directors, because the 90 days starts from that 90 days starts from that declaration. But before the declaration, I think the base resolution plan and the informal meetings with the banks should have been held. So appointment of the IP may be done with the terms: one, the fee for the pre-IRP role, pre-PIRP role. Then secondly, the terms and the terms of the appointment should also say the fee and expenses for conducting the entire PIRP. So that's a second eventuality. One eventuality is that the application is filed and not admitted. So what would be the fee for the RP for the pre-PIRP role? That would be paid. Second, if the entire PIRP is conducted, then what would be the fee, including expenses of including some of the expenses? Of course, that again comes to the same situation when we do in CIRP. Some of the expenditures are supposed to be approved by the committee of creditors in off and on meetings, and some of the expenditures are supposed to be approved in each meeting. Then the fee and management fee and expenses of the insolvency professional if the management and control is taken over under section 54J. Section 54J says that during PIRP, if the promoters are conducting some transactions fraudulently and the financial creditors are not satisfied with the conduct during the PIRP period, so they can immediately invoke section 54J, and they can say that the RP should take the management and control of the business and not the directors or promoters. So even there is a form which is prescribed in the regulation, form P3, which would clearly provide for the terms and conditions of the appointment of insolvency professional for the assignment. So after the appointment of the insolvency professional, the financial creditors will meet off and on, and they will deliberate on the base resolution plan, eligibility of the corporate debtor. They will also verify the MSME status of the corporate debtor. They will also verify the eligibility under section 29A. And then they will go for approval. They will go for approval of PIRP and approval for submission of application to adjudicating authority, and that approval will be in form P4.
So before you move forward, maybe we can take some questions till the stage that you have discussed so far, that is, submitting the plan with NCLT for the approval, or maybe, the process post the PARP has started from the NCLT.
So I'm still on this process. Only one little line is left, because see, it is so in a
you can just complete this slide and then we will take some questions.
Yeah, in a scenario where there is no unrelated financial creditors, or there is no financial creditors, then the same process would be conducted with the operational creditors. And as against CIRP, where we used to have 18 financial creditors, in these regulations we would have 10 operational creditors. All other process would be same as we had in the CIRP for operational creditors. The application for the approval for filing application from financial creditors, that would be in form P4. Now I can take the questions which actually up to this level.
So one confusion that has been created because of maybe some news in the media also is that the PIRP is limited to amounts up to a default of up to 1 crore rupees. So I believe this has been clarified that there is no ceiling of the default amount. The minimum default needs to be 10 lakh rupees, and you have also clarified that this 10 lakh rupees can be a single default, it can be an operational creditor default, it can be any default, and that default is good enough for the CD to initiate a PIRP. So correct me if I'm wrong.
Absolutely.
In this
No, you're
interpretation.
absolutely right. And this 1 crore figure is already there in the code. So that is only the power of central government for a notification of a amount of default. See, whenever we say that the notification would come, so in this case the notification has come, it is 10 lakhs, and the central government doesn't have any power to notify amount which is more than 1 crore.
So the limit of 1 crore is actually for the government to notify, so it is not something that we need to worry about.
So the default can be 10 lakhs, or default can be any amount which is more than 10 lakhs.
So Prashant Tripathi ji is asking that is the CD eligible, is only the CD eligible to submit a base resolution plan? I guess yes. That is how the
Yes,
PIRP
yes,
is
yes, yes.
envisaged. That is how,
At this stage,
yes.
it is only the CD who would prepare a base resolution plan and would submit it before the financial creditors. But later on, there is a process which is a normal process in CIRP of invitation of resolution plans. Again, the same structure when the RFRP would be issued, the information, the invitation to public also would be released. So there will be a document inviting public, providing all the information. There will be an information memorandum. So everything would be there. Everything would
Okay.
be there.
So Sushil Agarwal is asking that if so he's asking for a comment on the independence of RP if he prepares the base plan or if he's involved in pre-PRP IRP period. So any limitation in the law that a consultant who was involved with the CD helping the CD prepare a base resolution plan cannot be the RP in the said case?
I have not read that. I have gone through the regulations, and the eligibility of the uh, eligibility for appointment as RP is the same as it was in CIRP. Like he should be eligible to be appointed as independent director on the CD. He should not have been auditor, cost auditor, the secretarial auditor for the corporate debtor. He should not have been a consultant who have provided a consultancy of more than 5% of the revenue of the consultancy organization. So if this is what is probably, and there is no such mention that the insolvency professional would not be engaged in preparing the base resolution plan. In fact, the base resolution plan should be prepared by an insolvency professional. He would be able to explain it better to the financial creditors. He would be able to explain in the meetings of the financial creditors. He would be able to understand the mind of the uh, financial creditors and accordingly modify the base resolution plan, and finally would achieve a consensus on a base resolution plan which will be approved for which will be finally submitted for the approval for filing PIRP application.
So I will also add to it that independence of the RP is also preserved in this manner that Dr. Sahu said this in the webinar that he conducted the other day, where he clarified that the independence of the RP is being preserved by the way of keeping his fee preserved. So when the RP is appointed, the RP is not reliant on the CD or its promoters for the fee that they will get. So therefore, if the RP is appointed post the PRP process, he will remain independent because his fee for the insolvency period will be fixed prior, and the funds for that fee will also be preserved by way of transferring to a separate account. Because his thought process and what he shared was that in case of PIRP, in case of CIRP, the insolvency professional is in control of the funds of the company, whereas in PIRP he may not be. So that's also something that will add to the independence of the RP.
I'll
So,
definitely come to this, Ankit, but then
hmm,
in this regulations, the regulator has proposed that the CD will open a separate bank account,
yeah,
and that bank account will be operated by the RP.
yes.
And in that bank account, the CD will first of all put that money, which is the estimate of the fee and expenditures to be incurred by the RP. So that, of course, with the approval of the committee of creditors, but that expenditures has to be contributed by the corporate debtor. So there is no provision here uh, that the committee of creditors will contribute for the funds. So
Mm.
the biggest difficulty that most of the insolvency professionals were facing in the past 2 years, 3 years, that the funds are not available with the CD and these contributions are not coming, interim finance is not coming. So how to conduct the process? Now, in case the corporate debtor is interested, so genuinely those companies will come in this PIRP structure, only those which are having operations, which are not dead companies, and the promoters would be interested in reviving the company. So this is real restructuring process, of course, with some cautions as we'll discuss while we go forward.
So apart from that, I think the next question that I can take up is benefit of PRB versus OTS. Mr. Atul Pandey is asking for it. So I believe you can take this question later also.
No, I think this is a beginning question. I definitely would like to take up now because
Yeah.
see, there are a lot of apprehensions. Like, let me even share my experience. I have been involved in the restructuring and OTS for the last 35 years. And I have seen that most of these restructuring and OTS proposals are not having any timeline. See, you keep visiting banks, you keep addressing them, you keep calling them, you keep visiting them, and they may or they may not take any step for OTS, they may not take any step for structuring. Every time you go, they would put up a different condition. Now it's a committee approach. Now it is like, even if it is a one creditor, there may be some unsecured creditors also. Even if there is a one bank, there may be some unsecured creditors. So it all depends. Like, see, for example, in the case of home buyers, if there are banks and there are financial creditors by the name of home buyers, so if the home buyers collectively approve a kind of base resolution plan, and the builder also agrees to that, so all this litigation before RERA, all this litigation before consumer courts, all this litigation before CIRP, there is no requirement of collating 100 people or 10% of the allottees. So this can be a structure which can be a resolution between the allottees and between the builder, because the builder is also interested. He will also get some kind of moratorium. Nobody will actually catch hold of him. He will also get some relief out of some kind of government liabilities, out of statutory liabilities, operational creditors liabilities. So he will focus on the section 53 is applicable in these cases also. But the only scenario is that, yes, whenever there is a haircut, the promoter might have to say that they'll have to take dilution in the equity. Now, the dilution in the equity, as I understand, would be that there should be some change in the management. The promoter should not continue in case he's causing losses to the creditors, like in operational creditors, financial creditors, statutory authorities. The the dilution in the equity should be there. However, the COC has the power, in case the COC thinks that this kind of dilution is not really important, and the COC would have to record reasons, and they can still approve a resolution plan without a dilution. So where the promoters are continuing, the haircut is also given, and the operational creditors are also given haircut. So that process, but then this process has to be with the due competition with the public, not exactly what the resolution plan submitted by the corporate debtor. See, why a banker will take a decision on OTS, and when there is a separate where there is a separate structure is available. The bankers were not comfortable in signing any OTS proposal. They were not comfortable in signing any restructuring proposal. Now this is a committee structure. This is a structure which will have the stamp of NCLT. So they can definitely say, okay, go ahead, let's start, and let us see all the creditors would agree or not. So this OTS is in other case also, the OTS is only possible in case there is someone who actually has that kind of money to settle with the banks, and the most of the bankers are asking for upfront in the case of OTS. However, in this kind of PIRP, the restructuring, the deferment, in case you would see the total what can be done, the regulations have already been released. The regulations of the regulation 37 is exactly the regulation that we have now in this case also. It is exactly the same. So every possible powers that the COC has in CIRP, all those powers even the COC has during PIRP also. So should I continue, Ankit, for the next slide?
Yes, I believe you should continue.
So 66% is required for appointment of insolvency professional as RP. So it is not being appointed as IRP, it is being appointed as RP. So there is no structure where the IRP would be replaced by another RP. That process is not there. However, section 27 is applicable. In case during PIRP, the COC feels that the selected IP is not doing the duties, or for any either other reason, the COC still has a power to change the RP, even during this 120 days. The maximum time of the PIRP is 120 days. They have three powers, but there is no requirement of changing the IRP to RP or RP or changing the IRP to a different RP. Similarly, 66% voting is required for even giving an approval to file PIRP. There also 66% is required. So when we file a declaration, the declaration is to be filed by the majority of the directors. And when a special resolution is required from the members, and the special resolution as under the Companies Act would be, that also will be a special resolution. So these are the basic document which is required. Now this is the role which is called a pre-PIRP role of RP. Pre-PIRP role of the RP starts from this slide. Till now, the RP was doing only a service to the corporate debtor for which he may take a fee or he may not take a fee. Now from this, when this RP has been selected by 66% vote of the financial creditors, his duties start. And from this, it will be 90 days period. Within 90 days, the application has to be submitted to adjudicating authority. And he will continue till the time the adjudicating authority passes an order, either rejecting the PIRP application or admitting the PIRP application and starting the PIRP period. So the duties of the proposed RP immediately after his appointment is that he would prepare a report, and there is a format for the report, and that report format is P8. It has been released in the regulations. P8 is the format for the report. In that report, most of the financials and the process that has been conducted, the base resolution plan, everything is supposed to be conforming to section 54K. Different sections have been made, but everything it is the duty of the RP to see, consider, verify everything according to section 44K is confirmed. That is the first report which will be filed, and that report will be in form P8. That report has to be filed and with the other documents to IBBI also. And for IBBI, the IBBI also will take that report. So the other duties can also be conducted, and the financial creditors may even tell the RP to do some duties during this period. However, the duties of RP will cease. This pre-PIRP role will cease in case the application is not filed within 90 days. If the application is not filed within 90 days, this role is ceased. This role also ceases even if the application is accepted or application is rejected by the adjudicating authority. So there are three circumstances that the pre-PIRP role is seized. One, from the date of declaration by the majority of the directors, 90 days has lapsed and no application has been filed before the adjudicating authority. So the role of the RP is seized. Secondly, the application is filed and the application is rejected by the adjudicating authority, the role of the RP ceases. Application is accepted by the RP, the role of the RP pre-PIRP role is ceased. Then the role starts as RP. So I think this is clear at this moment. The pre-PIRP role ceases in three circumstances. From the date of declaration, from 90 days have lapsed and no application has been filed to adjudicating authority, PIRP application is rejected or it is accepted. So everyone would be interested how the fees would be decided, who would pay the fee. So I thought the slide talking about the fee should actually come at this moment. Before everyone would start looking for clients, everyone should understand what kind of fee and what kind of job role that would be required in this kind of assignment. So I am very clear that whatever you discuss with the corporate debtor, understanding their financial position, understanding their assets and liabilities, understanding whether they would be able to get some haircut or not, everything is before your appointment as RP. So whatever fee that we are discussing, we are not talking about that part of the corporate debtors. Understanding of the financials, understanding consultancy, preparation of base resolution plan, that is not that I am discussing. You may or you may not charge any fee for that part. That report is not supposed to be prepared by an insolvency professional. That report is to be prepared by the corporate debtor. Whether he is taking any help from his own chartered accountant, he has prepared himself, or there is no certification required on this report, on that particular base resolution plan. It is not supposed to be prepared by any any professional regulated by any regulated under any regulation. So it is not supposed to be prepared by a chartered accountant or by a company secretary or by an advocate. So there is no certification required for this base resolution plan. So the base resolution plan can even be prepared by the directors himself. If they understand if they also do the business plan, if they also try to restructure the business for bringing profits, for improving EBITDA, and for even showing repayment of the debt. So one, that the RP will get fee for the duties before the application is emitted by adjudicating authority. So as I said, when this fee would be decided, there will be 3 fees. One is for the pre-PIRP role. So that fee would be decided with the financial creditors with 66% voting. So this fee, this part of the fee will become part of the PIRP cost if the application is admitted by the adjudicating authority. So if it is not admitted by the adjudicating authority, then the corporate debtor will have to bear this. In fact, the entire cost has to be borne by the corporate debtor. But this still there is a concept of PIRP cost, as we had a concept of CIRP cost. That actually would be discussed later, because there are eventualities when this CIRP can be converted, the PIRP can be converted into PIRP. The PIRP can also be converted into CIRP in between. And secondly, when the management and control is also taken over by RP with the directions of COC, which would be decided by them with 66% vote in favor of taking over the control and management. The fee and expenses incurred by the RP shall be determined and paid. Section 54 says COC will have powers to impose limits and conditions on such fee and expenditures. There are some expenditure that can be fixed, like fee, per month fee, or for different assignments fee. So there can be, for example, the report that is supposed to be made, and there can be a fee which can be a lump sum fee for giving a report, and also for the pre-PIRP role. I'm not sure that the banks would be ready to accept a fee per month for this role, because after you give your report, it will be only the job of the lawyers to go for the to file an application before the adjudicating authority and to attend to all the hearings. The RP would not be having any role. So for this period, I believe a lump sum fee would be acceptable to the committee of credit, to the financial creditors. Secondly, the COC may also have to impose some limits for traveling, for limits for other expenditures, office expenditures. So all that the COC can impose. The COC also has the power to approve, because in this case, as in the case of CIRP, the COC would be constituted after about 7 days of the start of PIRP, and there may be some expenditure. In fact, there generally will be some expenditure which will be incurred by the RP before the COC constitution. COC has the power to ratify those expenditures also. Now here comes the main protection. In case the corporate debtor does not file the application within 90 days after even the approval, after the appointment of the RP, or the application filed by the AA is rejected, the fee of the services will be paid by the corporate debtor and it will be borne by the corporate debtor. So in this case, it is also provided in the Regulation 8 that the corporate debtor shall maintain a separate bank account to be operated by RP for the fee and expenditure. So the RP would be able to pay the fee and expenditure. RP will be able to issue checks to the valuers, and also would be able to issue checks to the other professionals appointed by him. For example, the forensic auditors also may be required to be appointed by him. So all this is required to be issued by the RP. The payments will be made by the RP. The bank account would be at the control of the RP, And see, whenever we open such kind of bank account, I think the bankers also would have to be given instructions that the corporate debtor, the directors would not have any authority to change this signatory in this particular bank account. See, so far, if the directors are saying they can also pass a resolution that the signatory in this particular account is also changed, so that also has to be restricted, that during this PIRP, this signature, the signatory would not be changed. So that kind of resolution would be required for opening this separate bank account. COC will approve an estimate of fee and expenditure, and that amount would be deposited by the corporate debtor in the bank account. And from time to time, it is not really provided that the entire amount will be deposited by the corporate debtor. However, the corporate debtor will deposit as advised by COC from time to time. The Even otherwise, the RP has a duty to disclose the cost to IBBI at the time of his appointment. That also is required in this case as per the regulations. RP shall also disclose the item-wise cost to IBBI, as normally also the IBBI takes during CIRP. So, this is the definition of PIRP cost, and this PIRP cost has also got a kind of interim resolution, interim finance cost and interest on this. The fee paid to any resolution professional, expenditure is incurred by any such professionals, any professionals appointed by the any professionals appointed by RP. So all that has been considered as the PIRP cost. Even the uh, authorized representative uh, in case of class of creditors, that concept is also here in this PIRP, and the expenditures and the fee of the AR, that also is kind of part of the PIRP cost. So I think at this stage now we should talk about the how the application can be filed. The application, in case we see this stepwise, or Ankit, in case you think that now presently we are at 5:10, so in case there are some questions at this level, I can take up some questions.
Yeah, so some questions, I will just ask a few questions that were good questions. So one question was that in case of a real estate entity, how will that fall under an MSME? So I think a PIRP for a real estate project will not be possible unless and until the company itself wants to go for it. Am I correct in that interpretation?
Now, see, first of all, we have to see what is the definition of MSME. MSME talks about for manufacturing and for services both.
Yeah.
And the real estate company is considered to be a company providing services.
Yes.
And any company providing services, they actually can get registered as MSME, and that particular real estate company is also eligible for PIRP.
But then but the promoters and the controlling people, the directors, the shareholders of that company have to say yes to a PIRP before anything happens in that real estate project.
No, see, it is very important. It is very important because normally there is a dispute between the home buyers and the builder. And the disputes are resolvable provided there is a stamp of a judicial authority. So they can meet, they can discuss like what is the kind of difficulty that they are facing. Like the possession has been delayed. There are multiple applications which are actually pending before RERA. Multiple applications are pending before NCDRC. Multiple applications are pending before economic offense wing, or even the arbitrations, or even the normal court, arbitration court, or so there are many such cases where the dispute is because maybe 2%, 3%, 5% of the home buyers, they have gone into different courts, and because of this deficit in trust, everything is standstill. So that can be resolved by having these kind of meetings, and also kind of giving powers to them of appointing an RP, and also getting the resolution plan approved before even the PIRP is filed. If the home buyers are satisfied that the builder would be investing say 50 crores or 100 crores and would complete the possession in the next 1 year, and then in case this he is committing this, and they will also say that we will also make payment, so both of them, the home buyers will say yes, we would start releasing payment to you, The builder say that I will contribute 50 crores. But however, the only
So there is
condition is
a
that
so there is a possibility of a deadlock being resolved where
there is a
the
possibility of deadlock being resolved. The builder will say only one thing, that my 50 crore will be considered as interim finance.
right.
And that they agree, that they may agree, because this is something which is what has happened in the reverse insolvency. In this reverse insolvency, in this principal bench order, uh, so it was almost a similar case, but that was a kind of reverse insolvency. Now also the builder can come and builder can say that I would be able to give you the possession within 6 months or 1 year, and you have to do this and I will do this. So that is a resolution, and its MSME registration is very easy nowadays to get this done.
Right. So Mr. Debasis Bhattacharya is asking that what are the valuation requirements under PIRP?
I will come to that slide. There is a regulations have been released regarding valuation, and I will come to that because that's part of the deliberations.
I will come to other questions. There was another question that I had parked for discussion. So difference between a Section 10 CIRP application and a PIRP. That was a question that I had shortlisted.
Section 10 doesn't have any consensus of the financial creditor. However, Section 10 also is possible in case the updated information is filed before the adjudicating authority. In case we see the list of documents which is required for a Section 10 application, and in case we see this PIRP application, you would see the documents required will be almost similar. The information required will be almost similar, because see, in this particular case, during PIRP there is no requirement of inviting claims. In fact, the corporate debtor has to provide a detail of creditor to the RP. So there is no process of inviting claims and the public would be submitting the claims. So in case of suppose a real estate company, if all the particulars of the home buyers are available, the RP can start negotiating with them. RP can prepare any insolvency professional, any consultant can start with them a dialogue with a base resolution plan, and they can all come up to the mutual understanding of kind of breaking the deadlock.
Yeah. Other differences can be that a Section 8 application will not provide any preference to the CD's resolution plan, whereas in a PIRP that will be the case. Maybe in a Section 8,
no, I think
Section 10 application.
Practically, this base resolution plan, in case it doesn't involve any haircut, then it can be accepted as the resolution plan, and maybe that the COC would accept this without even inviting the resolution plan from the public. But if there is any haircut, if there is any loss to any financial creditor or operational creditors, then the base resolution plan cannot be accepted. Then the resolution plans has to be invited from the public at large. Those resolution plans will have to compete with the base resolution plans, and then only the resolution plan, final resolution plan, will be accepted.
Right. So, so that's a difference between Section 10 application and PIRP. So that's dealt with. So another question is pre-PIRP period also 90 days from the date of appointment of RPs by the FCs?
Yes, it is basically the two things are basically happening together. The 90 days start from the declaration of the majority of the directors. So the first thing is, first process is preparing a base resolution plan, discussing informally with the financial creditors, and then at one particular point of time when you feel that the most of the financial creditors are in loop, then the declaration. From the date of declaration, the formal meeting starts. In these formal meetings, the formal meetings will be invited by the corporate debtor, and there is no resolution professional. The formal meetings will be convened by the corporate debtor. There is no resolution professional. In these meetings, in these formal meetings, the creditors will consider the eligibility, they will consider the base resolution plan, they will consider the 29A, and then they will say, yes, okay, we would like to go ahead with the PIRP, and then they will appoint a resolution professional. That is the date when the resolution professional's work will start. it is not for 90 days. It may be even for only, it may be only for 15 days. Because see, from the date of declaration to the date of approval of the financial creditors, it may take 80 days. And for the last 10 days are left. And for the last 10 days, the RP will provide their report. RP will provide its own check and balances and will submit the consent and will submit the application for PIRP to the adjudicating authority. So the pre-PIRP role, it can be 90 days, it can be less than 90 days, and it can be even a few days only, because the most of the time is consumed by the financial creditors in selecting the RP, and most of the time is consumed by the financial creditors in finally getting a good base resolution plan and giving an approval. So this is something which is practically maybe even a week's time that you get, and you get a fee for this also.
So to summarize, there is an informal period which has, of course, no ceiling in the act, or there is no time limit to that. One can negotiate with the financial creditors for as long as they want to. Yeah. Then once the authorization is passed or declaration is passed by the company in its board or in its shareholders meeting, after that this 90 days starts, right?
So see, like, I think this should not be misunderstood. So there are two things that I'm talking about. One, that once the PIRP starts and it gets rejected, no further PIRP can be started in the next 3 years. But this process of pre-PIRP, this you can start 10 times in a year.
Yeah.
Because you have to just engage with the financial creditors. You have to just talk to them with a base resolution plan. And in case they find that this particular resolution plan is acceptable to us, then of course they can go ahead with this. And till the time they don't apply to adjudicating authority, so that means there is no restriction of 3 years.
So one part is, of course, to have multiple PIRP applications. To restrain that is one objective. The other objective, I believe, is also that once the company says that I want to go ahead with the PIRP, putting a time-bound process for the financial creditors to approve that base resolution plan and then getting it submitted to the NCLT for starting the PIRP process. That time limit is having that objective. And then once the PIRP is initiated by the NCLT, then of course there is another timeline, that is 90 days, then 30 days for the
120 days.
NCLT to approve. So 120 days post the NCLT approval date.
Post NCLT approves, yes.
So basically there are these stages, which this is how I think I can summarize. So maybe you can continue. I will take up more questions if they come up.
So the as probably I would say that this is like a lot of people are associated with us today. I'm very happy to see the number of participants. So this now this is the process of filing of application. The applications of the for PIRP can be filed by the CD or any member who is authorized by the constitutional documents, or it can be filed by the CEO, or it can be filed by the CFO. That means that the corporate applicant is defined under Section 5. The application can only be filed if all the requirements under Section 54A are met and the process is completed, which is as per the declaration which is given, and the format for the declaration as cited is also given in Form P6. So at stage 2, the Form P6 is there. In the rules, they have already provided Form 1 for filing this application before adjudicating authority. The fee has been decided as 15,000 rupees. The form can be filed electronically. This application can be filed electronically. Before the application is filed before the adjudicating authority, and the one copy has to be submitted to IBBI, and the evidence of submission to IBBI also has to be enclosed with the application. The various documents are required to be submitted, like list of financial creditors, list of operational creditors, list of financial creditors for appointment of RP in Form P3, written consent of the resolution professional in Form P1, the declaration by a majority of the directors to be submitted in Form P6, copy of a special resolution of the members is to be submitted, approval of the financial creditors is to be submitted in Form P4, report of the RP is to be submitted in Form P8, and there's a very important part is that the declaration of preferentials, undervalued, and the the fraudulent or extortionate transactions, also there is a form regarding the kind of information and for the purpose of understanding any transaction which might have been taken by the corporate debtor. That form is P7. So all this is required before an application is filed before the adjudicating authority. So these are many documents which are supposed to be submitted. In fact, the form has come. I will not spend time on this. The form 1A, the form 1 of the rules is a very, very elaborate form, and that form has to be filled up, and most of the item mentioned there. So if a company is not having up-to-date accounts, if a company is not having complete data of the debtors, creditors, assets, liabilities, transactions, the company would not be able to file that application. So the accounting and information is required, then only the filing can be done. Now the next part is the application is filed. So the NCLT, while they would be adjudicating on this application, the NCLT will only examine any deficiency in the application. And if there is any deficiency, the NCLT will notify the deficiency and the applicant will have to correct it within 7 days. Although it is written again in the code that the NCLT will admit or reject the application within 14 days. And it was also written in the in section 7 and 9 and 10 that the application would be accepted or admitted or rejected within 14 days. But that has actually been, the timeline has already been discussed in JK Jute order, and it is not to be, it may not be complied with because these are considered to be directory and these are not considered to be mandatory for the NCLT or for any other court. So the PIRP shall be considered as commenced from the date of admission of the application and not from the date of receipt of the order. I have carefully checked it because the order may be received a little later, but from the admission of the application, the 120 days period will start. The adjudicating authority will appoint RP in order, in the order of admission itself. The RP would be the same as proposed in the application, provided no disciplinary proceeding is pending against the insolvency professional. If the disciplinary proceedings are seen to be pending, and then the adjudicating authority can actually recommend any person from the IBBI. I think the same panel which is being maintained by IBBI and provided to NCLT, the same will be used if the proposed insolvency professional is found to be having any disciplinary action pending against him. The adjudicating authority will also direct the resolution professional to make a public announcement of the PIRP immediately after his appointment. There is a provision for public announcement also. Section 54D deals with the timeline. So the total timeline has been given as 120 days from the date of commencement. However, the RP is supposed to submit the resolution plan duly approved by the Committee of Creditors within 90 days. If no resolution plan is submitted to adjudicating authority within 90 days, the RP shall file an application after 90 days to the adjudicating authority for termination of PIRP. So if the 90 days period is lapsed, then the application will be filed for termination of PIRP, and there is a form given in the regulation that is P13. P13 is the form given for the application which is to be filed by the RP for termination of the PIRP. Okay, so what kind of moratorium is available after the PIRP starts? The moratorium would be starting from the date of the PIRP and from till the end of the process. The moratorium would be same as provided in section 14 of the code. However, the subclause 2 is not available. Subclause 2 is which is regarding the essential services. That part is missing from the moratorium. It is only the subclause 1 and subclause 3 which will be given to PIRP, and the subclause 2 would not be given. So uh, the institution of suits, continuation of the pending suits, transferring, encumbering any action, foreclose, recovery of any property, all this will be available. Section 14, that will be available. The that also would be available, like the license, permit, registration, everything would be available. Subsection 3, which is again not really functional as of now, because see, the central government has not notified any kind of transactions in consultation with the financial regulator. So that subsection 3 is also not applicable. However, in case, the regulation says that if uh, this management, if the management of the business is taken over by the RP during PIRP on the request of the COC, on the resolution of the COC, then even the uh, essential services kind of moratorium would also be available to the corporate debtor. Let us understand the duties of the RP during the PIRP. The duties of the RP is a little lesser than CIRP. So the number one is that the asking for the claims, verification for the claims, and there is a better process which is involved. And somehow I believe this is a much better system. The first of all, the list of creditors which was submitted in form P2, that finally would be submitted. The different format of that would be submitted by the corporate debtor to RP, which will be considered as a list of claims, which will be submitted by the corporate debtor to RP, and that would be submitted within 2 days of the initiating PIRP. It is the duty of the RP to inform each and every creditor regarding the claim which he has confirmed after looking into the books of account. So the first process is the corporate debtor will provide list of claims to RP within 2 days. RP will verify the books of account. But what I understand is this part also has to be done even before the adjudicating authority passes an order. So that is the reason that I'm saying that the RP will have to work with the CD, because see, the timelines are so constrained that within 2 days, within 5 days, everything would not be possible. Most of the things would have to be done while the adjudicating authority is listening to the application, is hearing the application. So the list of claims and the confirmation from the books of account, the verification of books of account as regards each claim, it cannot be finished in 2 or 3 days. So this is something that will have to be done even while the application is filed with the name of the RP, but he started doing his work because the corporate debtor is also interested in you. The corporate debtor is also cooperating with you. So the RP's functions, RP's duties are supposed to be done, and the CD has to cooperate. So this work also can be done before even the PIRP order comes. The creditors will be confirmed from the books of accounts in some other documents. The RP will also have power, but those powers, of course, will not be there before the PIRP order, because after the PIRP order comes, the RP will have the power to call for some more information from the creditors. The creditors will also come up with their objections, because maybe in the books of the corporate debtor some different amount is there, and the creditors will have some different amounts. So then there will be some kind of communication to and fro from the claimants, and finally a list of claims will be finalized as which is called the list of claims confirmed by the RP. So it is not considered to be collated, it is not considered to be verified. So we have two such things. In CIRP, we used to say it's collating of claims. In the liquidation process, we used to say verification of the claims. In PIRP, the third form is the confirmation of the claims. So the confirmation of the claims by the RP, by looking into the records of the company, by looking into the other documents and other relevant information, that is considered to be the confirmation process. Then the RP would maintain this updated list of claims because of various disputes, because of various communications, because of various objections. The RP will maintain this list of claims every time any such objection comes. He would also be required to monitor the management of the corporate debtor. See, when I say monitoring, the RP will be supposed to attend all the board of directors meeting, all the shareholders meeting. He would also attend all the committees meeting. And in the regulations, I have seen that the uh, RP has the power. RP has the power to uh, provide, see, to visit the company, to ask for the information, to ask for a monthly report, and that is the power that the RP has. RP is not controlling, but even the COC can also provide that the promoters would not do a transaction, maybe for example beyond 10 lakhs of rupees or beyond 1 crore of rupees, or the COC can say that the promoters will not do a transaction for sale of the assets. So all these conditions that can be actually imposed by the committee of creditors in the very first meeting. So this will be monitored by the RP. Of course, the management, the business will be done by the promoters, but it will be monitored by the RP. So the RP also has to see that the business of the corporate debtor is not conducted in a fraudulent manner. The COC actually can impose some threshold limits on the conduct of the business by the promoters during the PIRP. Monthly report, as I said, regarding the legal proceedings, key contracts, and key material impacts. The RP's power is to well, like kind of get the information of the company from the corporate debtor. So RP will constitute a committee of creditors and will attend all the meetings. The RP will also prepare information memorandum on the basis of the preliminary information memorandum, which is submitted under section 54G. RP is also supposed to file applications like COFE applications for avoiding transactions under section 43, 45, 49, 50, or 66, if any. And there's a new section also 67A that also would be added into all these transactions where the penalty of 1 crore is proposed, and such other duties as may be proposed. And the other duties as per the regulations have also proposed some duties, as I said, the like monthly report and updating, looking into the fraudulent transactions. The any item of section 28 of the code, those of course would have the COC would have the power. Now in this case, the COC would have the same power. However, earlier the COC was putting conditions and limitations on the RP, but now the COC is putting conditions on the corporate debtor. All approvals, all actions, all activities under section 28 will have to come to the COC. The COC can also say that more than this particular amount transaction, the COC prior approval is required. So all this is part of the regulations as regards the duty of the RP. So the powers of the RP has been slightly more than the CIRP powers, and more so regarding the accessing the books of account records of the information available from the board of directors. Accessing the electronic records of the corporate debtor, the RP can access the information utilities record. The RP will have access to the books of account records with the government authorities, statutory auditors, accountants, and such other persons as may be specified. The RP has those powers. RP also has a kind of powers to attend the meetings of the members, shareholders, board of directors, committees. The RP will have the powers to appoint accountants, legal professionals, and other professionals as the regulation has provided. The RP will also collect information relating to the assets, finances, operations of the corporate debtor, and would also understand whether the avoidance transactions are being done or not. The RP will collect the information of the total business operations for the last 2 years, total financial and operational payments for the last 2 years, the assets, liabilities. All these powers of the RP is to get some information from the corporate debtor. RP is also authorized to get some information from the banks, and the RP is also like in case all the personals of the corporate debtor, the promoters of the corporate debtor, they shall extend all the assistance to the RP for the information required by him. So in The RP also has a power to file an application under to the adjudicating authority under section 19(2), read with section 54F, seeking directions to such persons. Even in PIRP, there may be some certain information which is pertaining to the uh, avoidable transactions. The RP may feel difficulties in getting that information, and the RP will have to file an application under section 19(2) in such cases also. So the regulation says that the RP would also have power to get information from all the professionals and advisors engaged by the corporate debtor. The RP will also have the information, or the RP will also have some powers to access the depositories of securities from all the registrars. They record the ownership of assets, like the registrar of documents, registrar of properties, CIRP, registrar of vehicles. So the contractual counterparties, like in case the CD is dealing with some people, the RP will have the powers to even seek information from them. So I think this already I have discussed what are the preparations to be done by the CD before PIRP. I have discussed it at length. The board resolution, special preparation of base resolution plan, everything I've done that. See, what is the difference between the PIRP and CIRP? So I think quickly we can just run through the differences, although the process is different substantially. At the later part of the process, this 120 days where we actually supposed to invite the resolution plans, this seems to be a little challenging. But the one is that the CIRP, this is with the consent of the promoters, shareholder, directors, whereas in the CIRP it is not with the consent. So this is least litigation would be seen in PIRP. As far as the resistance would be considered, there will be least resistance from promoters. So the application can be admitted by adjudicating authority in a shorter period. It's a mix of judicial and consensual process. The corporate debt remains under the control and management of the promoters under the supervision of the RP and also under the supervision of the COC. The corporate debtor has the right to prepare a base resolution plan, and principal approval of the creditors is required even before the PIRP starts. This is a quicker process. It only requires 120 days as against much higher in CIRP. There is no concept of IRP in this PIRP, and there is no concept of appointment of RP consequent to IRP, further to IRP. Consent of the financial creditors for appointment of RP is required, so there is no change. There is no change required later on after the PIRP initiates. However, Section 27 is applicable, so they can remove the RP at any point of time. Once the PIRP application is filed, no application can be considered before disposing of PIRP application. So this is also a kind of protection given to the companies that they can apply themselves for the PIRP, so that nobody else should apply for 7 and 8, for 7 and 9 section applications. If the PIRP fails, the CD would not be liquidated, but the PIRP would be terminated and the promoters would continue to run the company. So the company would not be liquidated in case the resolution plan is not approved. That means the PIRP is terminated and the company is like running as it was running. There is no claims required to be filed. It is only the claims, the list of liabilities, the list of creditors are supposed to be given by the CD. RP will only confirm with the books of accounts and the other relevant records. RP will not run the project. RP will not run the company. RP will not run the sale purchase processes. The company will continue to run by the promoters. It is only the monitoring by way of attending board meetings, by way of inspecting the assets, by way of inspecting the transactions. That, of course, by way of asking a monthly report, MIS. Even at times, the committee of creditors can also say that we will appoint some internal auditor during this period, and that also can become PIRP cost part. So there is a penalty provision if the promoters does not declare complete list of creditors or any other information which is required. So there is a provision of penalty, and the section 67A has been inserted in the act, and that penalty is also very harsh. Now I am coming to the definition of MSME because this is very important. So we should actually consider there are three parts of the MSME part: micro, small, and enterprise. We will only say the maximum limits. So investment in plant and machinery should not exceed 50 crores, and the turnover of the company should not exceed 250 crores. However, there are very like detailed things that we must know. How to do the calculation of plant and machinery, because the plant and machinery should not be more than 50 crores. So the plant and machinery investment in plant and machinery is linked to the income tax return of the corporate debtor. Add that too for the last year. In case of no income tax return on the basis of self-declaration of the new units, and in the case of self-declaration for the new units, the cost of the plant and machinery would be considered without GST. Now, when we see this income tax definition, the income tax definition is used for plant and machinery other than land and building and furniture and fixture. So everything is plant and machinery as per Income Tax Act. It includes all plant, machinery, equipment, electrical fittings, vehicles, trucks, buses, ship, aeroplanes, software, books for profession. Everything is part of the plant and machinery. Even the cars are also part of the machinery. Even the buses, ships, everything is plant and machinery. So it is very clear that other than land and building and furniture and fixture, the entire fixed asset schedule as per the Income Tax Act would be considered as plant and machinery. However, as per the while calculating the investment in plant and machinery, in case we can do further slicing and dicing, then the cost of pollution control equipment, research and development, industrial safety devices, and these may be excluded. And there is a notification also, and that notification is very old, 2005 notification, and that still continues because that particular notification that particular notification also provides some of the investment in plant and machinery which has to be excluded, and that investment is maybe some molds and dies that is they covered there. Now the turnover is supposed to be calculated based on the information available in the income tax returns and the GST and CGST returns, and the export of goods and services or both has to be excluded. So in case a company is doing a turnover of 5,000 crores, and out of the 5,000 crore, 4,800 crore is export, and the investment in plant and machinery is less than 50 crores. So this particular company will also be considered as MSME because the investment in plant and machinery is less than 50 crores, and the turnover as defined here, domestic turnover is less than 250 crores. The turnover figures will also have to be taken as per the PAN, and in case of a new unit, it will be on a self-declaration. Of course, the registration of MSME is mandatory, and the registration has to be done in Udyam registration online. Udyam registration portal is there, and on that there are some documents has to be uploaded, and the registration can be applied. After the registration, the enterprise will be referred as Udyam, and there will be some number given to every enterprise as Udyam registration number. The E certificate is also given, which is called Udyam registration certificate, that also can be given. So all the existing enterprises to get fresh registration after 1st July 2021, existing registration would be valid only up to 31st of March 2021. So till now, everyone who actually has the limits of 50 crores and 250 crores, they have to now apply for a fresh registration because the existing registration is already expired up to 31st of March 21. Information to be updated on the Udyam registration portal based on the ITR and GST returns for the previous financial years. And this is the regular process that we need to upload the information of ITR and GST returns. Otherwise, the MSME registration status can be suspended. So Ankit, is there any question till now? Because then how do we decide? Because there is a much important part of the entire process would be coming, and how to handle with that process. So either we can have because after 2 hours, after
Yeah, it
15
becomes
minutes,
difficult for anyone to concentrate. So it's
yes,
already like 15 minutes to 6.
yeah,
So my thought process is that we can take up the questions for the next 15 minutes, and the remaining presentation can be done as part of a part 2.
So part
That
two,
would
like I will
be,
just conclude that once the PIRP application is admitted by adjudicating authority, the public announcement would be made by the RP, and that has to be made within 2 days. And there is no requirement of giving advertisement in the newspaper. The RP is only supposed to send this public information to all the creditors, because in this case, the list of creditors is available with the RP. So he has to convey the public announcement to all the creditors individually, and it will also be given to the information utility and also website of the CD if there is any. So that is the kind of publicity, that is the kind of public announcement which is to be made. So as far as the from now onward, because from the claims to the base resolution plan to the invitation to the RFRP to the competition and finally the approval of the resolution plan and various other things we need to do in our part two, and then we only would be able to get the concentration from the participants. The subject is very important for most of the professionals. This is very important to understand, because the most of the chartered accountants, they would have the first information of any financial stress in any of their clients. So they would have to understand this process. So the part two will come up. So we can take up questions, Ankit, because otherwise
so
after
Krishna,
two,
yeah.
yes.
So Krishna Mohan Galamudi ji is asking, in case both the turnover as well as the PNM investment in PNM part parameters need to be fulfilled. I believe both need to be
Yes,
fulfilled.
both. There is a word, very big word, and both has to
Yes.
be
So
fulfilled.
both need to be fulfilled. Then we have a very interesting question from Krishna Mohanji. Who would chair the COC meetings under PIRP?
The RP will chair the meetings after the RP's appointment. So there are meetings which are before the approval of the financial creditors, before even the appointment of RP. Those meetings would be convened by the corporate debtor, and there is no provision, there is no regulation, no provision regarding who would chair. To my understanding, there is a provision for giving notice to all the financial creditors. They would attend, but since the meeting is convened by the corporate debtor, so it will be there is no provision like who will chair. So it will be the corporate debtor who would convene the meeting, and he may ask any of the bankers to chair the meeting, whosoever is the largest stakeholder. So, however, after the appointment of the RP, after the PIRP application is admitted by the insolvent adjudicating authority, RP will chair the meeting.
So then we have a question. I think this is already answered, that who will chair. So I think this is also answered, that if the CD does not record the amounts due to creditors in the books, then what happens to the creditor's claim? So in case the creditor does have a claim which has not been reported by the CD in that list of creditors that he's supposed to give, does he have a recourse to bring that to the attention of the RP?
Yes, the any creditor, because see this the list of claims, the list of claim is supposed to be a public information. The list of claims will be filed before the IBBI in a format electronically. The list of claims will also be uploaded on the website of the company and would be regularly updated. The list of claims would also be the it will be given to all the respective creditors. I think the question is very valid. In case the corporate debtor is not providing information about any creditor, what recourse that creditor has. So that creditor will definitely approach RP and say that my claim is there, and there is a penalty which can be even up to 1 crore in case the corporate debtor is not providing any information which he was supposed to provide to the RP. So that new section, which is 67A, that we will cover in part 2. But this
So there is always this possibility that a creditor will say that, no, I have a due, and the CD will say, no, that due is not valid. There is a dispute of that due.
I see a lot of litigation on this part.
Yeah. So
I
this
definitely
part, I think we can research further on how will this part be tackled, because
No,
in
it is
case
only a
this goes
practical part
into,
of it. As far as the research is concerned, as far as the regulations are concerned, I have gone through. So there is nothing such which is mentioned in any of the regulations or in the code. It is very clear that if there is a claim and that particular claimant has to come, the RP will modify. No,
So one practical approach to that can be that the CD can be encouraged, or CD can also report those claims of creditors which are disputed in his opinion, and even if they're not recorded in the books of accounts, and then they can still be part of the list. I don't know, like practical part
I
which
think the
can be discussed
CD
further.
needs to be educated. The
Mm,
CD would have to be told that if you would hide any claim,
mm,
and that would be your responsibility, because it is not the public responsibility. In the case of CIRP, if the public has not filed a claim, that means any haircut that would be applicable to everyone whosoever has filed a claim. Here in this case, if the amount is not being disclosed by the creditor, if the amount is not disclosed by the CD, and later on there is an amount due, and that particular person was not there in the list of claims submitted by the corporate debtor, so there cannot be any haircut applicable to that person.
yeah,
So that person will continuously claim.
right.
I think there is a deterrent to the CD to
There's an
hide any information.
mm, mm, mm. So understood. So if the proceeding is already going on against the CD in High Court for particular claim, can PIRP proceed with initiated process can be initiated simultaneously. So I don't think there is any bar.
No, I think the disputes or no dispute, as far as the claim definition is concerned, the definition of claim continues to be as per the CIRP. There
Yeah.
is no change in the definition of claim. Now, the claims can be disputed, can be resolved, can be undisputed, can be matured. Everything
So
regarding claims.
existing litigations against the CD or done by the CD against other people should not stop any PRP process, if that's
No,
what
it
the
cannot.
question.
It cannot.
So then we have a question on CD needs to submit the list of claims, including disputed claims disputed by creditors, without approach to judiciary as of now. And so I think this is just a comment. What will be the role of lenders to whom CD has given corporate guarantee and guarantee has not yet been invoked? So I think it should become part of the list of the financial
Yes,
creditors.
the list of claims very specifically provides for the guarantees also,
Okay, so
because
that's
the
already
regulation
covered.
provides very clearly that the guarantees also would be considered as a liability. Guarantees given by the corporate debtor, that also will be considered as a liability, and that should be included in the list of claims.
So Umesh Karji had asked that how a creditor would claim whose claim is not in the list will come to know about it. So I think you've answered that it will be in public domain.
Yeah.
Then if there is no public domain in news, public announcement in newspaper, many OCs will be deprived of claims. So that is not the case. This will be public announcement will be there. So
Public
it will be.
announcement will be there because the IBBI would have a special portal for this kind of claim, and electronically the updated list of claims would be submitted to the IBBI, and the list of claims will be subject to inspection by any creditor, any person who actually would like to say that I just had a claim with this company. So he has the power to inspect the list of claims. So that power has been given to all creditors. Whosoever says that I'm a creditor, I'm a director, I'm a member, I'm a shareholder, they have the power to inspect the list of claims. And also it will be there on the list of, it will be there on the portal of the CD.
Yeah. Can PRP be initiated against guarantor of a CD if PRP is proposing a haircut? So I think if the PRP has to start with the consent of financial creditors. So if that is the case, then that is the case. If the haircut can be proposed by a CD, and I don't think that's a problem if the majority of the financial creditors are agreeing to it.
Yes, haircut can be proposed. Haircut, whenever there would be haircut, the resolution plan will definitely be put into competition, and with the best resolution plan available. So this is structure that has actually been defined in the regulations, structure of competition between the resolution plans, that is very clear. All depends upon the committee of creditors, what are their preferences. Even the even this the structure, the regulations also talk about a kind of the significantly, how much would be, what is significantly higher, that is also defined, that also would be decided by the committee of creditors. Then there is a new concept called tick size. There's a new concept of tick size, and the tick size is like when in this Swiss challenge process or whatever, because the name has not been used in the regulation or neither it has been used in the ordinance, but the Swiss challenge is also, it will be electronically done. The Swiss challenge process will be on for about 48 hours, and there will be items where you can improve on the resolution plan, and that also will be decided by the committee of creditors. This is exactly what we used to do in our open bidding processes. And electronically, everyone would keep improving their resolution plan, and within 48 hours, whatever would be the best, and that would be finally put to vote by the committee of creditors. So that I will completely explain that process. I've understood it completely, although I could get only about 10 hours last night and today morning. I have understood the complete process of how the resolution plans finally would be competing with each other. What is the kind of scoring system? What is the kind of, what is tick size? What is significantly higher? And how the evaluation would be done? Everything is very clear in the regulations.
So
Of course, yeah.
So question is that how are the interest of the OCs protected? I think that's a very popular question here, that how will because the financial creditors are deciding everything, the CD is proposing a resolution plan. What is the law say about protecting OCs? Will you like to
First
take
of
that
all,
up?
in case the base resolution plan, in case the base resolution plan propose any haircut to operational creditors, then the base resolution plan cannot be approved without inviting the resolution plans from public. So if the corporate debtor, and certainly the corporate debtor will definitely say that, yes, I propose to submit a resolution plan with haircut from operational creditor, that may include the statutory liabilities. Once this is done, so that means the base resolution plan as such cannot be approved. So the public invitation for the resolution plan would be done. So the evaluation matrix will be decided by the committee of creditors. The significantly better, significantly higher scoring system, that score would be decided, tick size would be decided. The most of the resolution plans will come and they would compete with each other. So then finally, all these resolution plans will compete with the base resolution plan. So this is the concept of competition. Finally, the best resolution plan would be put to vote.
So nothing to protect that OCs will get at least this much.
The OCs, protection of the OCs would be certainly there is a provision, like in case there is a haircut, then the equity of the promoters would be diluted. That is very important, that in case there will be no haircut to any person, like financial creditors or operational creditors, then the promoters can continue with their 100% equity. In case they propose haircut, then accordingly the management has to be changed. So in case they propose some kind of haircut, then they might even say that, yes, we would go for the 50% change in the management. So the 50%, for 50%, there is a new person coming, there is a new management who is coming, and that also would have to be approved. See, although the committee of creditors are empowered to approve a resolution plan without a dilution in the equity, but that probably would be seen by the adjudicating authority, how much efforts the COC has made, and how it is really possible that the corporate debtor comes and they seek every haircut, and that haircut is outside the financial creditors. If the committee of creditors says that there will not be any haircut to the financial creditors and the entire haircut would be to the operational creditors, that probably would be restricted. So if there will be haircut, that haircut would be almost proportionate to financial creditors also, as well as to the operational creditors also. So there is hardly any scenario where the financial creditors will not take any haircut, since they are part of the COC, and all the haircut would be taken by the operational creditors. That is something where the protection would be done by the adjudicating authority.
I think we can take the last question before we wind up for the day, whether there is concept of assured liquidation value for the dissenting creditors.
Same provisions are there for the operational creditors, and same provisions are there for the financial creditors, dissenting creditors. Okay. There is no change. The financial creditors and the operational creditors, they have the same provisions as we have in the CIRP.
So the next question is, when are we scheduling the second part?
So we have one webinar tomorrow between 4 to 6. So we can actually do this on Monday if it is not, because the Monday would be again a working day for everyone. So what is the, uh, because for taking it to the next weekend will be very difficult. So I think we should propose, we should propose maybe 7 p.m. on Monday, because everyone would be comfortable at 7 p.m. or like, because working time would be difficult for everyone to concentrate.
Yeah,
What
so
do you
there
say?
is always few people will say that this is work, so
Yeah, yeah.
there can always be this mix. So I think we can make it 6
Maybe
p.m. on
5 to
Monday.
7, 5 to 7,
5 to 7 can be done, or 6 p.m. can be
or
done on Monday.
or 4 to 6, whatever you feel like.
So I think we can make it 5:30, and maybe we can keep it for 2 hours till 7:30.
Right.
So 5:30 on Monday is what we're keeping it for. And of course, we'll be sharing recordings for all those who are not able to attend it. But it will be better if everyone attends it, so that we can have more questions, and questions are really helping the process of understanding this PIRP better. So we have about
Let's say like there are 49 questions. I believe you've already attended
I
all
have
that.
attended some 46, and there are about 50 which are still open. Some of these might have already been answered though.
And we might
So
even take up on Monday.
yeah, so we will try and download these so that we can kind of make sure that
Now,
this
see,
can
like
be taken care of.
we actually proposed this webinar, and it was restricted to ordinance, and we never thought that on this.
We have comments where people have commented that 5:30 will not be convenient. So many people are saying that 7 p.m. is better because after post work is suiting them better.
Okay.
So I think we can shift it to 7 p.m. Many people have commented and said that they will like this to be at 7 p.m.
I think 7 p.m. is okay then, Vilas.
Okay, then 7
So,
p.m. is the
so I
final
think
time.
I should actually give the reasons for this, because otherwise we thought that it will be restricted to the ordinance only, but then we never expected that the regulation and the rules also would be notified so fast. So it was only last evening that we could get this regulation, and then the entire process gets expanded. And now, since it is absolutely ready, even the applications can be filed tomorrow. Everything is notified. So everyone has to work on this. So there is no way that we should go ahead for another 1 week. So Monday, 7 p.m. will start for the second part of it.
All right. Thank you everyone for this very active participation, and pleasure to be part of this very new subject.
Thank you very much, participants. And as I always say, that it is my way of learning. Keep remain connected and keep spreading your knowledge around. So that's thank you very much for the time being. Have a very good weekend. Thank you.
Thank you everyone.